Minister, you're very welcome, and your officials also. In a moment, Minister, I'll invite you to make your opening statement to the committee, and after that then members will have, I'm sure, a number of questions for you. Before that, I wish to draw your attention to the fact that by virtue of Section 17(2)(l) of the Defamation Act 2009, witnesses are protected by absolute privilege in respect of their evidence to this committee. However, if you're directed by the committee to cease giving evidence in relation to a particular matter and you continue to so do, you're entitled thereafter only to a qualified privilege in respect of your evidence. You're directed that only evidence connected with the subject matter of these proceedings is to be given, and you're asked to respect the parliamentary practice to the effect that where possible you should not criticise nor make charges against any person, persons or entity by name or in such a way as to make him, her or it identifiable. And members are reminded of the long-standing parliamentary practice to the effect that they should not comment on, criticise or make charges against a person outside the Houses or an official, either by name or in such a way as to make him or her identifiable. And once again, if you have mobile phones, you might turn them off, please. Minister, if you'd like to.
Thank you, Chair. I want to thank the committee for the invitation to talk about the miscellaneous provisions withdrawal of the United Kingdom from the European Union on the 29th of March 2019 Bill 2019. Parts 11 and 12 of the bill fall within the remit of my department, so I appreciate your time and your engagement as we bring forward this bill with the hope of addressing some range of critical issues that may arise in the context of a no-deal Brexit. There are only 5 weeks remaining until the 29th of March. The Government and the EU remain committed to securing a negotiated Brexit outcome, and my department and I have been planning for a long time now for many scenarios. In light of the uncertainties in London and the Brexit deadline of the 29th of March, the Government decided at our meeting of the 11th of December last that immediate priority must be given to preparations for a no-deal Brexit, and that government departments and state agencies should urgently take forward work on that basis, and that's what we have been doing. This is a very wide-ranging bill, but given the emergency nature of the legislation, the Government took the decision that progressing this through the Houses as an omnibus bill is the most sensible way to ensure that we have the necessary legislation enacted before the 29th of March. The bill covers the issues in primary legislation that need to be addressed immediately in the event of a no-deal Brexit. Measures relevant to the case of a no-deal Brexit were identified following a detailed examination by all departments of legislation currently in force. The Government published the general scheme of the Omnibus Bill on the 24th of January, and the draft bill contains 16 parts addressing primary legislation issues which would require immediate attention in the event of a no-deal scenario. Since the publication of the general scheme of the Omnibus Bill, intensive work has been carried out between government departments and the Attorney-General's Office. On the basis of this work, there have been some updates and amendments to parts of the draft bill. The Government has discussed this proposed legislation throughout our meetings in January and February, and its provisions were also subject of intensive and daily engagements between departments and Parliamentary Council. The bill will underpin the Common Travel Area CTA and ensures that the associated rights and entitlements of Irish and British citizens under this long-standing arrangement will continue in any circumstance, and this is one of the Government's 4 key Brexit priorities. I want to outline the purposes of Part 11 and 12 of the bill in turn, Chair. Part 11 sets out amendments to the Social Welfare Consolidation Act of 2005 in order to maintain the status quo of the Common Travel Area. My key concern of area, and I know a concern that's shared by this committee, is that the impact of Brexit on those current reciprocal arrangements for social insurance, which includes our pensions, and social assistance, which are our means-tested schemes linked to residency rights, and child benefit between Ireland and the United Kingdom, including Northern Ireland. There are approximately 132,000 people in receipt of a UK state pension living in this country, and approximately 1,000 customers receiving child benefit payments from the UK for children residing in Ireland. There are 28,760 people residing in the UK who are in receipt of a state pension contributory from Ireland. 840 people residing in the UK are in receipt of full-rate child benefit payments from our department, and these payments are in respect of 1,830 children, 95% of whom reside in Northern Ireland. A further 920 people residing in the UK are in receipt of child benefit supplement payments from my department, and in respect of 2,010 children, 97% of whom reside in Northern Ireland. We want to ensure the continuation of these payments, and that's what we're doing with this legislation. My objective is to ensure that the reciprocity of social welfare rights and entitlements which currently exist for Irish and UK citizens moving within the Common Travel Area are safeguarded and maintained. Ireland and the UK share a long history of cooperation and reciprocity in social security matters because the principle of reciprocity has been reinforced in bilateral agreements and arrangements on social security between the two countries since 1924. That reciprocity is underpinned by the principle of equal treatment so that Irish citizens enjoy the same benefits as UK citizens and vice versa. These rules are designed to protect people moving and working between each state and to minimise any disadvantages they might experience. From a social welfare perspective, maintenance of this status quo through safeguarding and preserving that very reciprocity of a crucial importance to me and indeed to the Government. Because of the unique nature of the Common Travel Area and the associated rights and privileges which it provides and will continue to provide for Irish and British citizens in each other's countries, it was agreed that Ireland and the UK would formalise the pre-existing Common Travel Area social protection arrangements in a legally binding document. That agreement was signed on the 1st of February and is now subject to the ratification process both in Ireland and the UK. Under the terms of the agreement, all existing arrangements with regard to the recognition of and access to social insurance entitlements will be maintained in both our jurisdictions. And this means that the rights of Irish citizens living in Ireland to benefit from social insurance contributions made when working in the UK and to access social insurance payment if resident in the UK are protected, and indeed vice versa. As part of the ratification process, the agreement was laid before the Houses on the 7th and the 8th of February. It was subject to a Dáil motion on the 12th of February, and Chair, I will be discussing it at Select Committee tomorrow with your good self and my colleagues on the 21st of February. The ratification process is also underway in the United Kingdom. Now, while I am confident that the ratification will be completed in both jurisdictions before the 29th of March, I want to be absolutely certain that the export and payment of benefits between Ireland and the United Kingdom and vice versa can continue, even if all the necessary steps in the ratification process are not completed by that date. And that's the overall purpose of the amendments in Part 11 of the miscellaneous bill. The draft heads, as published in the general scheme, were intended to provide the Minister for Employment Affairs and Social Protection with powers to make regulations relating to a range of issues such as the treatment of events of facts occurring in the UK, the taking account of social insurance contributions made and paid in the UK, the habitual residence condition, the avoidance of multiple payments, arrangements in relation to the absence of from the state provisions, arrangements regarding frontier workers, where the frontier crossed is that between Ireland and the UK, the exchange of information, and arrangements to ensure maintenance in the current arrangements vis-à-vis the UK, as the current arrangements governed by the EU regulations are more expansive than the existing bilaterals with the United Kingdom. There have been a number of changes made to Part 11 as the drafting process progressed, although it's important to note that the overall aims and the outcomes remain unchanged. During the drafting process, a more streamlined approach emerged, which effectively allows the Minister, or me in this case, to make an order to provide for the implementation of the signed agreement, which has not yet been ratified, where she is satisfied that the other party is in the process of ratifying it. An order has also been drafted to give the effect of this if required. And as a result, most of the provisions initially envisaged are not required as they were intended to achieve the same ends, so the bill, as published, will look quite different to the general scheme in this regard. In addition, the regulations which were envisaged by the initial draft heads should not now be required. Other amendments insert specific references to the UK into a number of sections of the Social Welfare Consolidation Act so that the same rules will be applied with regard to the treatment of the UK under these provisions when the UK is no longer covered by existing references to member states in those provisions. And these amendments will ensure maintenance of the status quo with regard to social welfare payments in the event of a no-deal Brexit. Part 12 of the bill, the amendment to the Protection of the Employees, Employers Insolvency Act 1984. So Part 12 is to amend the Protection of the Employees Insolvency Act, which provides for the insolvency payment scheme. And the scheme covers wage-related entitlements of employees who are employed in Ireland by an employer who has become insolvent in Ireland or in another EU member state, which obviously currently includes the UK. Once the UK leaves the EU, employers in a state of insolvency under the laws of the UK will not fall under the scope of the Act. And that would mean employees of those employers who work and pay their insurance in Ireland would no longer be covered by the protection set out in the Act unless amendments are set out in this part of the Act are made. The purpose of the amendments in this part of the bill is to ensure that those employees will continue to be covered by the scheme after a no-deal Brexit. In order to achieve that, the amendments in this part of the bill provide for updates to existing definitions to the terms such as competent authority and relevant officer, for employees who are employed or habitually employed in Ireland whose employers are made insolvent under the laws of the UK continue to be covered by the scheme, that the date an employer is made insolvent under the laws of the UK will continue to be the date an employer will be regarded as having become insolvent for the purposes of the scheme, that amounts certified by an actuary or a person performing a similar task in relation to employers made insolvent in the UK and the employees are habitually employed in Ireland continue to be covered by the scheme, and that information can be exchanged in line with the provisions of the General Data Protection Regulation with the relevant officer appointed to an employer which is in a state of insolvency under the laws of the United Kingdom. In the economic uncertainties which may prevail in a no-deal scenario, I think it's vital that we continue to provide this kind of protection to workers in Ireland, and that's why I'm introducing these amendments. Colleagues, the timetable for the bill: we expect to publish the full omnibus bill on Friday the 22nd of February. It's our intention that it will go before the Dáil for second stage from the 26th to the 28th of February inclusive. It would go through Dáil committees and report stage from the 4th to the 8th of March. It will then go to the Seanad for second stage between the 11th and the 12th of March inclusive, followed by the committee and report stage in the Seanad on the 13th and 14th of March. This legislation is an essential part of the whole of government preparations for Brexit, and I appreciate genuinely the cooperation of not just only this committee but the entire Dáil and Seanad to ensure that this bill will get past all of the relevant stages between now and that dreaded date of the 29th of March. Chairperson and members of the committee, I want to thank you for allowing me to outline the legislative details and process so far, and I thank you for your attention, and I'm very happy to hear your comments and take any questions that you might have now.
Thank you very much, Minister. Just one general question. You set out the timeline, and obviously it has to be done before the 29th of March, but the way you've indicated it is the finishing with the Seanad on the 13th and 14th of March. I presume if there were amendments made in the Seanad,
it'll have to come back to the Dáil.
It'll have to come back. So from that point of view, it is a tight timeline.
Yeah.
Well, it's not just a question of doing. It's important that if there was something seen, that there is a physical opportunity to make that amendment.
Just to mention, the indication that we've been given is that the 26th of March would be the potential return date for if any amendments need to be confirmed by the Dáil.
Okay.
So as far as that's what we've been told, because we have put that question.
Deputy O'Dea.
Just on that point, I mean, I note the Minister says in her statement there that the Department has been working on this for a long time, but I mean, my understanding is that we're one of the last countries in Europe to actually be discussing this type of legislation. And I don't understand why it wasn't done much sooner. I mean, basically all we're asked to do here is pass legislation. Hopefully there mightn't be a no-deal Brexit, and there mightn't be any reason for ever implementing that legislation. But the way we're doing it now, it's rushed. It's a last-minute job. We're going right up against the date of the 29th of March, as outlined there in your reply to the chairman, and I think that's regrettable. You also mentioned in your speech that that the social welfare section of the omnibus bill will underpin the present legal arrangements for the common travel area. You will be aware, Minister, that doubts have been expressed about the legal foundations which presently exist for the common travel area. Can I ask you, is this agreement which you have signed with the British government designed to deal with those doubts, which were quite legitimately raised? I think it's very regrettable that we should be here today, legislating in this way, staring a no-deal Brexit in the face, because of the fact that a campaign was conducted in another country which was utterly misleading because of the fact that we have a parliament in another country which has become the laughingstock of the world, in view of the fact that we have a Prime Minister in another country who is more interested in keeping our own party together than in the welfare of the people. It's very regrettable that we're literally staring in the face the possibility of a hard border, tariffs which will wipe out our agri-food industry and general disruption. But that's where we are, so I presume we have to get on with it. We won't, of course, be opposing the bill, but I do regret that we don't have more time to consider it. I suppose the main questions I'd be asking is, insofar as the 2005 Act is concerned, the amendments to the Consolidation Act of 2005, have you covered every possible angle there? I noticed that in the definition in the Act referred to, in the 2005 Act, the definition of social assistance doesn't include, for example, domiciliary care allowance. Maybe there's a good reason for that. The other thing I'd ask you is, how long will it take you to produce those regulations? You know, as far as the 2005 Act is concerned, basically you're giving yourself the power to produce regulations. How long will it take to produce those regulations? Are they amending existing regulations? And if so, could you indicate which existing regulations they're amending so we can have a look at them? I mean, what is the position? Let's assume that the UK crashes out without a deal on the 29th of March. What is the position as regards reciprocal arrangements for social welfare if the regulations haven't been in place at that stage? What happens in the interim period? I also want to ask the Minister about statements that were issued yesterday by a number of leading pension providers, financial institutions who pay pensions in the UK, who have expressed the opinion that people in receipt of those pensions, Irish people in receipt of those pensions, will no longer be able to receive the payments into their own bank accounts. Presumably they're coming into their Irish bank accounts at the present. The view of these, one of whom deals with a major part of the payments, private pensions to Irish citizens, as far as I'm aware, indicates that people may have to open a sterling account in the UK, which would be quite unacceptable. So basically, I think the suggested solution to that particular conundrum was some sort of a banking agreement, some sort of a banking arrangement to be agreed between the two countries at some time in the future, presumably before the 29th of March, though. So without going into the details, I presume we can, you know, and when we're discussing the bill, we can go into the details of the heads. I have a few questions in relation to them, but they're the general questions I just want responses to for the moment.
Thank you, Deputy O'Dea. Minister, because there were a number of issues, I'll allow you to answer them each one as you go along, because you might lose your train of thought.
I definitely would, Chair, so thank you very much. I appreciate that. Deputy, I'm not sure why you think we're very late to the day with regard to this, given that I have described in detail the amount of work that has been done by the Department with regard to the convention that started at the beginning of 2018. I think I've said it on a number of occasions on the record that I've travelled to London last year to meet my then counterpart, who was a lovely lady called Esther McVeigh. We both had similar intentions, which was after what hopefully would have been a deal or an exit from the European Union by the United Kingdom with a ratified agreement. We were going to have part of Protocol number 20, a bilateral arrangement with regard to the reciprocity of both of our social security arrangements. That deal was signed on the 1st of February, and it comes into play once it's ratified here, hopefully on Thursday, with regard to the Irish contingency, and it's currently in a 21-day resting period in the United Kingdom. When that deal is ratified by the UK Parliament and the Irish Parliament, which will most likely happen on the 19th or the 20th of March, there will be no need for this legislation, because the commitments that we made to each other as a United Kingdom and a Republic of Ireland will come into legally binding force. I'm preparing this legislation on the basis of that maybe something will happen in the United Kingdom that won't allow them to ratify that deal within the 21-day period. So actually I think we're being incredibly prudent. But I've also since discovered, and since drafting this particular Section 11 of this bill, is that I really don't need to draft the legislation to ratify that, because I have within our gift currently a regulation that we could sign on the basis of that the United Kingdom are in the process of ratifying the bill or the bilateral agreement, which they currently are, as we currently are. We could extend the legal arrangements that we currently have until that bill is ratified. So this is really in the case of absolutely everything else, and throwing the bucket and the kitchen sink at it could go wrong. But absolutely the intention for many, many, many months of both the United Kingdom's Parliament and I'm now working with the second Pensions and Work Minister, a lovely lady called Amber Rudd, and indeed our own department and our own government, is that we will do absolutely everything to ensure that the reciprocal arrangements that Irish people and British people have enjoyed in each other's nations for donkey's years will continue on and after the 29th of March, and that's what we're going to ensure. You've mentioned that there were some doubts legally. I'm not sure where you would have got that information from.
No, the questions have been raised about the legal underpinning of the common travel area. There have been suggestions that the legal underpinning is pretty shaky and that it would need more comprehensive legislation. There's been a number of academic papers, there's been a number of...
I think that may have been true insofar as that when we went and looked to try and find a legal definition and legal arrangements for the common travel area that have been enjoyed for many, many hundreds of years, there probably wasn't a very sound legal basis. But right now we have a bilateral agreement between Ireland and the United Kingdom for the reciprocity of all of our social insurance and social security arrangements, and so there's absolutely no doubt that it has a legally binding underpinning of both legislation as a convention in Ireland and now a convention in England, once both conventions are ratified by both of our parliaments. The regulations, again, as I suggested to you, won't need to be drafted if and when the convention is passed in both the Irish Parliament and the UK Parliament, but that once, if it is, and again I can't be sure that the kitchen sink won't be thrown at something, the Parliamentary Council are currently drafting regulations for all of the departments that are involved in the miscellaneous bill, and we will be well within the timeline for the 29th of March deadline. But as I said to you, Deputy, I'm very, very positive, as is Amber Rudd, that both of our conventions will be signed, will be legally binding and will be ratified by both of our parliaments long before, now I may say long before, it might be only 7 days before, but 7 days is a long time in politics around here these days, long before the 29th of March.
Minister, you wouldn't know what could be ratified or not in Westminster, so
you're right.
Let's be prudent and cautious. Senator Higgins?
Yes. Thank you very much, Minister. And again, I would like to commend the multi-strand approach, because I think it is prudent and it is appropriate that has been taken. And I know that the primary concern, as you've yourself said, is to ensure that for those who are very much reliant on their social protection payments, that there is a continuity there, and that whatever the concerns might be are in what, if we are, unfortunately, if it is the case that we end up having a kind of hard Brexit in that context, that we certainly try to bridge that scenario. And I think it is going to be important. Social protection is probably the department that shows it almost more than others, where people and families will continue to have both histories and families and relationships and everything that span across both territories. And I think that some of the measures we're putting here will ensure that those families, which I think are the basis of our relationship with our neighbour, are supported. I have a few kind of specific questions and concerns just around which maybe you could address. Minister, the habitual residency condition, I note that you're looking to make regulations on the habitual residency condition is kind of what's mentioned. It's very loosely put here. I suppose that's one where there's a number of issues pending on the habitual residency condition that have been raised in relation to it in the past, for example, its relationship with child benefit or not, and so forth. So again, is there perhaps scope within those regulations, not now, but to address maybe some of those issues? Is one issue. The issue was already raised just to make sure that we have that comprehensive cover of both all assistance payments and entitlements as well. The issue of paternity, maternity and parental leave, if you might address it, because I'm conscious that we do have parental leave legislation that may be almost coming at dovetailing in terms of the entitlements. So in terms of ensuring a compatibility between those allowances, because that you're moving kind of out of simply the payments area and into the area of payments and rights and entitlements, and perhaps if those issues have been addressed. And I guess that comes to, as you pointed out rightly, there's a long history of social cooperation around these areas since the 20s, but we also have the Good Friday Agreement and that rights pillar within the Good Friday Agreement, where social welfare payments, in a way, when you look at disability and certain other areas, are part of how we vindicate that rights component. There's a number of places where we are giving regulations in respect of third country. And again, maybe it's a question of how that fits with the UK and versus, other third country parties, and, how we balance that. Data protection concerns are kind of addressed somewhat under Head 7 of the section where we're looking at the exchange of information, and it notes that it will be compatible with GDPR, but perhaps you might expand a little bit. And that we've discussed this issue in the past. I'm certainly keen that we're able to have a system that functions, but how we can ensure that there is clarity as to the purposes for which the information is exchanged in order to ensure it is robust under GDPR, particularly in relation perhaps to EU citizens who are based in Ireland. Not every Irish person is an EU citizen, but citizens of other EU countries and so forth. I'm just conscious of how we ensure people who may have in fact a triple part pension effectively, so you may have those who have a pension from Germany, the UK and Ireland, for example. So just around how we plan to address that issue. Lastly, the part 12, which is where you're looking really at the employment area. Now, I recognise, and I think it's positive, that there's measures around frontier workers and how that's defined, and the question of kind of the employment rights in a case of the dissolution. But I'd like to maybe just ask, and it relates both to this bill, but also to what we all hope will happen is in terms of an agreed Brexit, employment standards, which is, within your remit. What wider provision is made? Because those are two very specific small issues of employment that are addressed with. But there are a number of other employment issues. For example, in situations where we have British companies who are contracted under public procurement at the moment and who may have contracts with the state, how do we ensure that employment standards are maintained and that anybody who is being paid by the Irish state, maybe in a 5-year contract, for example, that we don't see any diminishment of employment standards.
Thank you, Senator.
And I had some further questions, but I will leave them aside for later.
I have others. Minister.
Thank you, Senator. So first of all, actually, now that we've changed the bill, I know I flew through the statement, but from the heads of the bill to the actual published bill on Friday, it will be slightly different. Insofar as that we've changed the bill, we don't need now the regs with regard to habitual residence. It's already there in the reciprocal convention that we have between the United Kingdom and Ireland. And so, just so that you're assured, and I know you have issues with regard to habitual residence, and that's
in its implementation. Yeah.
But okay, so just if I can try and be as clear as I can. As it currently stands and is operated today, notwithstanding the anomalies that you think exist, but warts and all, as it currently stands and is operated today, is exactly how it will operate on the 30th of March. So we haven't changed it, we haven't deviated. What we've done is literally mirror exactly every single operation that occurs between Ireland and the United Kingdom and the United Kingdom and Ireland today in the Convention. And so with regard to how we actually administer the habitual residency clause, both in Ireland and the United Kingdom, nothing will change. It will be exactly the same. We've gone through every single scheme, and yes, so I know I've probably continually focused upon our pensioners and on our children's allowance, because they are the largest numbers of people, but there are other people who are on different and other schemes, and they will again be exactly mirrored image. So whoever is entitled to be on a scheme today, whether you're in the in receipt of it in Ireland or whether you're in receipt of it in the United Kingdom, because of transfers of data between both our countries, because of work practices and residency, that will be exactly as it will be on the 30th of March. And that does include paternity and maternity. Now, obviously, parental leave isn't on our statute books, and so we can't have a convention for something that we might do in the future, because I have no idea whether we'll ever get around to doing parental leave, given the precariousness of things at the moment. But if and when it is passed, please God, at the end of this year, we will then discuss extending the bilateral arrangements with the United Kingdom on that basis. But again, the whole aim and our initial wish from many, many months ago is for the United Kingdom and for Ireland to have an agreement that reflects the practices of the common travel arrangements for donkey's years in our future relationship, and that's what the Convention has. We won't be treating effectively United Kingdom as a third country because they are now part of the new bilateral convention. And again, with regard to GDPR, it's already within the convention that we will continue to share the data. So both Ireland and the United Kingdom are currently adhering to the current GDPR directive from the European Union that both of us have to adhere to. That's not going to change on the 30th of March. And also what's not going to change on the 30th of March is what you refer to with regard to employment standards. So the only thing that will change, Ireland's laws will be Ireland's laws, the United Kingdom's laws will be the United Kingdom laws. If there's English countries or companies coming over and working contractually in Ireland, they will continue to be obliged to work under our laws, and vice versa. If we have Irish companies going to the United Kingdom for contracts, they will continue to be working under the United Kingdom's laws. In the main, our laws are exactly the same at the moment. We're about to probably adhere and adopt Article 883 in the European Union on Friday, and the United Kingdom are still very much a member of the European Union on Friday. So when we leave, both of our regulations and our laws will be exactly the same. Somebody would need to make a change to those for us to start deviating. But I'm not proposing in this legislation or in the Convention to try and impose new regulations from an employment perspective on the United Kingdom's companies, other than what already exists on the statute books. And just
it's a single point, just to clarify. Given all the areas that are moving forward, do you believe that a review clause can be built in to this bill, the omnibus bill as a whole, to ensure that, say, in 1 year's time, given the speed with which it has to pass, that we are in a position to interrogate it in its work in more detail?
There's a review clause inherent in every single bill that anybody can bring an amendment to it at any time. But
given the speed of this particular...
Yeah, there's nothing stopping anybody reviewing any legislation, so I think that's probably true of this too. But as I said to you at the outset, I'm very hopeful that I won't actually need to pass, or indeed if we do pass, ever commence the legislation that we're discussing here from the Department of Employment Affairs in Section 11. Obviously Section 12 is different and it's outside the scope of the Convention. But yeah, I'm like...
Thank you, Minister.
Legislation is rock solid, is it?
Thank you. Thank you. Deputy Carey.
Thanks very much, Chair. First of all, I want to compliment you, Chair, on organising this meeting here today. It's very important that we had the Minister here, and I want to compliment her for coming here and for her presentation. It is indeed regrettable that we're here at all in reference to what Deputy O'Dea has said, but we have to deal with the hand that's been played, and I want to compliment you, Minister, and your officials for the huge amount of work that you've done in this particular area with your counterpart in the UK. There is a lot of concern being expressed to me from people in general in relation to their entitlements, how secure they are, and I welcome the fact that the bill underpins the common travel area and ensures that the associated rights and entitlements of the Irish and British citizens under this long-standing arrangement will continue in any circumstances. Just in terms of, say, could you outline what payments are covered by the agreement signed on the 1st of February 2019? And could you let me know, will pensioners in Ireland continue to receive their UK pension into their bank accounts as before and vice versa? And how will Brexit impact on the free travel scheme? Will the All Ireland scheme continue to operate? And again, I just want to thank you, Minister, for your work in this area.
Thank you, Deputy Carey. Minister, some straight questions.
Thanks, Joe. Okay, so the first answer, Joe, and thank you for your compliments both on behalf of my staff and the committee here. What payments? So the state pension contributory, carers benefit, health and safety benefit, illness benefit, treatment benefit, adoptive benefit, maternity benefit, paternity benefit, invalidity pension, partial capacity benefit, widowers and surviving civil partners contributory pension, guardians payment contributory, occupational injuries benefit, widowed or surviving civil partner grant, job seekers benefit, and family benefits that include the back to work family dividend, child benefit, guardians payment non-contributory, domiciliary care allowance, one parent family payment and working family payment. And the corresponding UK payments are all reciprocal to Irish citizens also. And with regard to the free travel that you asked me, The All-Ireland Free Travel Scheme was introduced in April 2007 through the programme for government based on an agreement with the Irish Government and the Northern Ireland Assembly, and it isn't subject to any EU legislation, and that scheme will continue to operate after Brexit unchanged. We're currently reviewing the contractual arrangements with TransLink, the company which is contracted to supply the senior Smart Pass care that is based in the UK, in Belfast and in Hull, to ensure that we have full compliance with the data protection obligations under GDPR obligations, and that work is well advanced and necessary, but will be completed before B-Day.
Just, Minister, just in relation to the pensioners.
So, sorry. Anybody and how they receive their payments today is exactly how they will receive their payments on and after the 29th. There will be no change. I apologise, Deputy O'Dea. You made a statement earlier on with regard to the article in the Irish Independent this morning. That relates to private pensions, which has nothing to do with our department, but I am aware that there is negotiations between those private pensions companies and the central bank with regard to a banking licence or something, but again, that's nothing to do with my department. Anybody that's receiving an Irish pension living in the UK or vice versa in Ireland will receive them in exactly the same manner as they've always received them from. There's absolutely no reason to change banks, to consider doing that, or to worry in any way, shape or form.
Thank you, Minister. Deputy Carey, are you happy?
Happy. Thanks, Chair.
Senator Nash.
Chair, I must say I'm pleased that the opportunity has been taken anyway to anchor the common travel arrangement, common travel area arrangements in law, as it were, because of course, as we all know, the common travel area arrangements kind of grew organically since the 1920s, and it's really important that those reciprocal rights are reflected in law and in bilateral agreements to enshrine them and anchor them into primary law to ensure that everybody's entitlements are protected. It's unfortunate, of course, that Brexit has precipitated this. It was probably a good idea anyway to enshrine these rights and entitlements in law. So I'm assuming that, of course, Brexit of some description will happen, unfortunately. But in any event, we will be proceeding with legislation to ensure that the reciprocal rights are enshrined. Am I right? Yeah, that's.
Well, it's
a fair question because it's probably a good idea to take a belt and braces approach anyway to enshrining these rights in legislation. Probably should have happened many decades ago. It didn't. Brexit's precipitated this. So can we expect to see...
The Convention will do that.
The Convention will do it, regardless of how Brexit,
it's irrelevant.
one way or the other, works out.
So it's doing exactly what you've suggested that we potentially should have done a long time ago.
Exactly.
Signed by both passes in both houses.
And I'm assuming that the British government would consider this to be a good idea in any case, and that you didn't experience any resistance from either Esther McVeigh or Amber Rudd or her officials, because I think this approach recommends itself anyway. There's great merit to it. Just in relation to employment rights, I mean, I think we can be all satisfied that the kinds of protections that Irish law provides to workers, whether from a British company or not, if they're working here, they will enjoy the same rights and entitlements and protections as any other posted worker under the kind of principles of the Posted Worker Directive, and that will remain. So I think that's a very positive thing and something that people will be reassured about. I'd like you, Minister, maybe just to elaborate on the arrangements regarding frontier workers. I'm assuming that what you mean by arrangements in relation to regarding frontier workers, where the frontier crosses that between Ireland and the UK, involves workers who are obviously resident on one side of the border or another, working across the border and so on. Because obviously there are several thousand people who are affected by this. Many people I represent in North Louth who will be concerned about this. Obviously crossing the border a number of times a day is just something that's taken for granted. People who are living in Dundalk, working in Newry, living in Drogheda, working in Newry, you know the situation well yourself. So we're going to be giving some legislative expression to those protections that are already enjoyed. So you might just elaborate a little bit on some of the issues that you encountered on that and the kind of protections that will be reflected in the actual legislation itself. And finally, I'd really like to welcome the move from yourself and your officials in relation to the amendment of the Protection of Employees Insolvency Act. That's very, very important. Of course, insolvencies occur all too frequently, and given the activities of British business here and related companies and so on, British parent companies. It's very, very important. So I think people again will be reassured that those protections that are currently enjoyed around insolvency legislation will be applied to anybody who happens to be made redundant in an insolvency situation if they're employed by a UK parent company.
Thank you, Senator Nash. Minister?
Thanks. I think you're probably right. Maybe we took an awful lot for granted of the common travel arrangements for many, 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 many years. And I think it's not until you go and look for the legal underpinning for it that you realise that it probably maybe came up short. The convention that we have signed and that hopefully will be ratified here in the next couple of days. And just to maybe briefly outline what happens in the UK. So we both signed the convention on the same day. They have a 21-day cooling period, which we don't have. So we both laid it before the Houses. I think it was laid before the Dáil last week with the motion to come to committee, which we're here tomorrow morning. The United Kingdom is slightly different. They have a 21 parliamentary sitting cooling day period. And during that cooling period, then obviously parliamentarians in the United Kingdom can make observations or suggestions to the convention. They do that through something called a Privy Committee, which is sitting on the 13th of March. And the day for which those 21 cooling off day periods stops or ceases is on the 19th of March. So I would genuinely hope that by the 20th of March, both the Parliament in Westminster and the Parliament here will have ratified the convention on behalf of both of our nations. In the event of that not happening, we have discovered during the course of the drafting of this miscellaneous bill, obviously, which we were instructed in December to do in the event of a no-deal Brexit, which was to replicate everything from my department's perspective that's in the convention, to draft it in the event of there being a no deal, because the convention was part of the deal, the withdrawal agreement, Protocol 20. In the event of it not being ratified, we were going to ratify the legislation with regard to how we will protect Irish citizens and all of the payments that are made to them. But we discovered during the drafting of it that once the convention had been signed and that the intent and goodwill of both parliaments was ongoing, which it currently is, that we didn't necessarily need to pass the legislation, that we could pass a regulation to continue doing what it is that we've always done on the basis of that the goodwill exists there for both parliaments to pass and to ratify the protocols. That's true of section 11 of the bill. It's not true of section 12 because it isn't included in the convention. So I will continue to pursue section 11 of this bill, because nobody knows what can happen on any day. But I am genuinely very positively disposed, because of the interactions and the intentions of both Ministers for Work and Pensions that I've had the pleasure of working with over the last 18 months, and indeed our own government, that the convention will be signed, and that what we have enjoyed from a security perspective in the common travel arrangements for many, many years will become subject to a bilateral agreement, and then will be subject to law. With regard to frontier workers, the common travel area obviously is a long-standing arrangement between ourselves, and it means that most Irish citizens can move freely to live, work, study in the UK on the same basis as that UK citizens come here. The rights and the entitlements include access to employment, healthcare, education, social benefits, as well as the rights to vote. So frontier workers, being persons who pursue an employment activity in one state and reside in another, returning there daily and at least once a week, are provided for in the agreement signed on the 1st of February in the same manner as they were under the European Union rules of social security coordination, as provided for in Regulation EC number 883/2004. So the arrangements that we've enjoyed as part of that directive that we all signed off as the European Union in 2004 is enshrined in the bilateral convention. So again, with fingers and toes crossed, if we get to the 20th of March and all goes well, then frontier workers will just continue to work as they always have, with exactly the same rights, privileges, responsibilities as they've always enjoyed since the convention, since the European directive was established in 2004. It means people who are employed in Ireland and living in the UK, and people who are employed in the UK but living in Ireland, will access all family benefits that are available to people in Ireland for family members who are residing in the UK as if they were residing here. So it won't matter where you live and work, as long as you live and work in Ireland and in England, and Scotland and Wales and Northern Ireland, sorry, within the two countries. In addition, the existing arrangements for frontier workers who become unemployed will remain. So if a frontier worker becomes wholly employed, their contribution record in the state of the employment, so for argument's sake, people from Louth who are working in Uri, their contribution record will remain recognised by Ireland as if it was today. So there will be absolutely no change, and so that will be ratified within the Convention on whatever day in March. But again, I will pursue the legislation in Section 11 of the Miscellaneous Bill, just in case.
Okay. Thank you, Minister. Senator Butler.
Thank you, Chair. Thank you. Thank you, Minister, for coming in. A lot of the questions I wanted to ask have been asked already, but I welcome the fact that the anchoring of the common travel area. I want to congratulate you, Minister, on the huge amount of work your department has done and the huge concerns that are out there. When you see the figures of pensions and child benefit, it's a huge amount of work you've got done. Just a few questions that I want to ask, Minister. Will there be any delay if a no deal on payments? And will any paperwork on both sides with a no deal for pensioners or people getting children's allowance? What about the provision of information to citizens? Because a lot of the time no information comes out and they're left in the dark at the last minute. And does the Minister expect an increase in unemployment as a result of Brexit, especially in the border areas? We've gone into the unknown here, Minister, and your department and the government have done a good job over the last 3 months. And unfortunately, we might see Britain going over the cliff when it comes to the 29th of March, which will be very, very sad. But I worry as we move forward in Britain. They've brought in legislation there that not many people know about, that when skilled workers come from other European countries, when England leaves Brexit, they will be allowed to stay for 5 years, and unskilled workers will be allowed to stay for 3 years. And that has been passed by the British Parliament. And I can't understand why there hasn't been an uproar all over Europe over that legislation, but it's there. Now, that's for another day, Minister, but I'd just like you to answer my questions, please.
Thank you, Senator Butler. Some interesting questions for you, Minister.
That's right. Well, I'm going to decline to comment on the last question that you've asked me, because it isn't my business or position to comment on what laws are passed in the United Kingdom with regard to their own sovereignty. But what I will say to you is that those particular laws don't relate to Irish people.
No.
So maybe that's why it hasn't given much cause for concern over here, because we have the convention of the bilateral arrangement. To answer your question with regard to delay and paperwork and concerns that people may have, the ambition is for people to wake up on the 29th to the 30th of March, and if you're Irish living in Britain and receiving an Irish con pension or child benefit payment, that you won't notice that it's the 30th of March at all. That will be absolutely no changes whatsoever. And exactly the same will be true the other way around. If you're a British citizen living in Ireland or Northern Ireland or receiving any contribution towards a payment of the schemes that I listed earlier on, you will notice no different. And I can say that comfortably because of two things. Because number one, either the ratification of the convention that we signed on the 1st of February will have taken place and will become a legally binding international bilateral that is recognised, and that will come into law, or in the event of it not happening, with the cooperation of both the Dáil and the Seanad, we will pass this very lengthy miscellaneous bill, and that will give me cover to be able to continue to make the payments that we are currently arranging. So there will be no delay, there will be no exchanges of paperwork other than the information flow that flows back between the UK agencies and the Irish agencies with regard to social security information, as currently happens. You are right. We haven't probably told citizens yet exactly what's going to happen, because if I was to come out and say today with an absolute guarantee that you don't have to worry about anything and everything will be game ball, as sure as eggs are eggs, something will happen next Tuesday, and you won't be able to guarantee. But our intention, and the intention of both the work and pensions ministers that I've worked with in the last 18 months, is that when you wake up the day after the United Kingdom leaves, whenever that may be, and it may not be on the 29th of March, the arrangements for social security and all of the schemes that I just detailed earlier on will be exactly as they were the day before. And the enjoyment of the common travel arrangements that we've had from an education, from a healthcare perspective, from a work perspective, from a social security perspective, will be exactly as they were and we've enjoyed for many generations. To answer your last question, Senator, There's no such thing as a good Brexit. I think I saw you, Deputy, earlier on this week calling it a stable Brexit. I actually don't agree. I don't think there's anything that could be called a stable Brexit. This is not going to be good for any section of Irish society, or indeed, in my opinion, in the UK society. And so given the impact it's going to have on businesses up and down the breadth of this country, I have no doubt that it will impact on my live register figures. And we have started analysis and we will be starting detailed preparations as to what we will expect and how we will provide the support for those people that will be impacted negatively arising from what may happen in the next couple of weeks. But our contingency plans are to make sure that we minimise as much for the Irish Republic and to make sure that the supports and any activation measures that we have there and supports for industry are in place to ensure that we have as least worst Brexit outcome as we possibly can for Irish citizens.
One or two just repeats, but Minister, just one comment I'd make, you saw the paper today where it made reference to the fact legislation would be brought in to ensure people would receive their payments and whatever. I think it's important that from your point of view and the Department's point of view, that you have a communication strategy in place. You may say it's premature now because neither the convention or the legislation has been passed, but people are still. No, there's a lot of people who have no concern because they're totally. Their payment, they've never left the country, their payments, whatever it is. But for anybody who might have been abroad for a number of years or any of those, they certainly have concerns. And I think as a department, you need to make sure that you have a satisfactory communication strategy in place. And we're saying it before something happens rather than after it. Deputy O'Dea.
Maybe I missed what the Minister said about the convention. The convention, if it's ratified by both parliaments, it'll make Part 11 unnecessary. But you're going ahead to pass Part 11 anyway. But in what way is it going to look radically different than what the heads are?
It's not going to look any different. It'll look exactly the same. But I'm of a mind that we shouldn't have all of our eggs in one basket. So in an ideal world where people have common sense, the ratification of the convention that was signed on the 1st of February would be something that we could be guaranteed will pass. We know in Ireland it's something that we obviously want. The UK Parliament would go through its normal process with regard to the 21-day cooling period, applications made to the Privy Committee, and it then would be passed. But with respect and absolutely no disrespect to the members of the British Parliament, I can't find myself on the 29th of May with it not passed Westminster, and I have an obligation to the 132,000 pensioners and all of the other thousands of people that I've mentioned earlier on, which is why we will continue to pass the legislation that empowers me from a legal perspective to continue making those payments. Now, if it transpires, Deputy, that I don't need to commence the legislation because the convention has been ratified,
I understand that. Yeah.
Well, then that's
I understand that. No, I was referring to your statement on page 8. As a result, most of the provisions initially envisaged are not required as they were intended to achieve the same end, so the bill as published will look quite different to the general scheme in this regard.
Yeah. The reason that the draft legislation and the published legislation on Friday will look slightly different is because when we were drafting from the heads, we discovered that actually, because the ratification process has actually started, so when the convention was signed on the 1st of February, we started obviously the drafting of the heads long before the 1st of February, and we were developing and detailing those over the last couple of months. Because the process for ratification of the convention has been started by both parliaments, I can actually extend the regulations that we currently use to pay all of the social security payments between Ireland and the United Kingdom.
Instead of amending them, yeah, I see, as they stand.
So we can extend that until the ratification occurs. So just for argument's sake, and I hate saying things out loud because sometimes they come true, so I expect the United Kingdom to have this ratified by the 20th of March. If it doesn't, if they all get bird flu and they're off for 2 weeks and it doesn't happen until the 9th of April, then I have the ability with the legislation to pass a regulation or to draft a regulation and sign one to allow me to continue to pay what we're currently paying until the 9th of April or whatever, I'm only using these dates, until the date that the convention is actually passed. But as I said to you, the intention of the Department of Work and Pensions and the Minister for Work and Pensions, and indeed our intention, is to continue doing exactly what we set out to do a year and a half ago, which is to have this convention passed before the 29th of March.
Senator Higgins.
Yes, a couple of very small follow-up points. One is The question, I think, Minister, in fairness, I had put a lot of different points, but the question around where we have 3-country issues. So, for example, whereby there may be a reciprocal issue if somebody has a partial pension from their contributions in Germany, which is a relationship.
No change.
Yeah, but where that relates to the UK. So, the UK.
Be no change.
So will there be the UK I mean, I'll maybe put the few in then, but that'd be really good to clarify.
So if I can describe it, just in case
Yes.
I've picked you up wrong. So we have an Irish gentleman, for argument's sake, who's
Yes.
worked some of the time in Ireland, some of the time in London, some of the time in Berlin.
Yeah.
And he retires, and his pension contributions will be an amalgamation of the 3.
Yes.
So it'll be the Irish system that pays him. The information will be shared through the social security arrangements that we have. The United Kingdom will continue to give us their details of the contributions that he made in London. The Berlin social security system will give us the details of the contributions he made in Berlin, and we'll determine what his pension is, and we'll pay his pension.
So I think for the person resident in Ireland, I think that will be clear. I think it's more for
It'll be no different. So when we talk about reciprocal arrangements, when I describe something that we do here, they will do exactly the same way.
In the UK. Okay, that's great. And then the other thing was the issues of insolvency and the question of access to assets. And I think we all remember things like Thomas Cook when they pulled out of, that there were real concerns around that worker. So maybe just a clarity around the arrangements in terms of ensuring that workers who are based in Ireland have access to the assets. And I just had 2 really short other questions. One was just to clarify in relation to the review. While I recognise all legislation is always subject to review, what I'm suggesting is that I think it would give assurance, given the speed with which an omnibus bill may need to pass through the Houses. I could obviously table a private member's business to attempt to, review the omnibus. But if there was a scheduled review coming from the government side, I think it would make it much easier in terms of if that was built into the bill as would be normal, and particularly given there may be a number of areas where effectively the right to make regulations may be given to the minister, but we don't want a situation where regulations are made on the base of the omnibus bill and that we don't have almost a sense of when they will come up for consideration or review, or the kind of nuanced work we might ideally like to do. And then my last point is, which is related, it's not to do with the legislation, but exceptional needs payments, because we do know that there are likely separate payments, but a number of persons who will become vulnerable potentially post-Brexit. And I'm wondering, are there plans within the department to either look at maybe potentially some more resources around exceptional needs payments, and also potentially a kind of review of consideration of what issues may arise in that area?
Okay.
Thank you, Senator.
So, legislation subject to review. I'm not the head honcho, so I'll have to just pass back your concerns.
I've passed it on to others as well.
That's no problem at all. But as I said to you, the purpose of this miscellaneous bill is because we potentially may be heading towards a no-deal Brexit. Unfortunately, nobody wants a no-deal Brexit, and so we're still working incredibly hard to try and ensure that we don't have a no-deal Brexit. Yeah. And if we have a deal, whether it's on the 29th of March or some other date later postponed, then this particular bill becomes redundant. And much and all, as an awful lot of work has gone into it, you'd nearly be doing your novenas that it becomes redundant. So,
indeed.
But I hear what you're saying, so I will certainly pass it back on. With regard to the assets, the law is as it is today. And so all I'm ensuring is that the law, if the United Kingdom become a third country, wouldn't relate to the employees, and not to be disrespectful to employers from the United Kingdom. The only people that I'm concerned about are the employees, and most likely they would be Irish resident employees of UK companies. The scheme currently doesn't pay out where there is assets. We only kick in where there is nothing. And so its other legislation relates to the particular governance of what you're talking about. So where the current legislation, and I think it's in the Department of Business and Enterprise, and actually you might be able to help me out here, that governs the arrangements of insolvency. This particular bill only kicks in from social protection, wherein somebody goes insolvent and there isn't a bean left to pay anybody, and we as a state won't leave employees with nothing. And that's all we're doing, is because if we did nothing, the United Kingdom would become a third country and they wouldn't be subject to this bill. And the Irish employees in UK companies wouldn't be protected. And so we're just extending to recognise that the United Kingdom is a third country, but it is subject to the bill, to make sure that we give that safety net, and hopefully it's used relatively rarely, thankfully, but to make sure and ensure that that safety net is still there. And to answer your question, there isn't an extra provision in our exceptional needs budget because it's entirely driven on demand. And so I may be sitting here, as I could be last year, next year, in 10 years' time, looking for supplementary, but it's entirely driven on demand, the same as our disability is, our jobs. So if anything happens to upscuttle the budgets that we agreed here, well, then we'll be sitting here later on having another conversation, but we certainly won't be turning anybody away. Okay.
Okay, Minister, thank you very much for your attendance today. Just in relation to the convention, to remind colleagues that we're meeting tomorrow morning at night. Select committee are meeting at 9 o'clock tomorrow morning to deal with that, and we're ahead of West. What's wrong, Minister? I
never answered your question. I'm sorry. So we have a Getting Ireland Brexit Ready website. That does actually detail, but I think I was just going to say it is a very good idea that you suggested, and the only thing I would say is that given that we know who the people are that would be affected, maybe we shouldn't put the willies up everybody, that we should only deal directly with the 130,000 people directly, but it's a very good point, and thank you. I took a note of it.
Just to make the point again, we're meeting at 9 o'clock tomorrow morning in Committee Room 3 to deal with the convention, and unlike Westminster, our remit is to have it referred back to the Dáil no later than the 5th of March. So we'll be doing that tomorrow. Minister and your officials, thank you very much for your attendance today. Colleagues, we will adjourn until Thursday the 28th of February at 10 a.m.